In January 2025, the Consumer Financial Protection Bureau announced a rule that would have changed everything for 100 million Americans carrying medical debt. The headline spread everywhere. Medical debt removed from credit reports, $49 billion erased, 15 million Americans protected. People celebrated. People stopped calling collection agencies. People assumed their medical debt was no longer a problem. 6 months later, July 11, 2025, a federal court in Texas vacated that rule entirely. Not delayed, not modified. Vacated. Gone. Dead. And here is the part that should make you angry. Most of the people who heard the good news never heard the bad news. Right now, as you watch this, millions of Americans are operating under the belief that their medical debt has been legally removed from their credit reports. They are making financial decisions based on a protection that no longer exists in the form they believe it does. Today, the full truth. What was actually removed? What was not? What debt collectors are doing right now in the gap between what people believe and what is actually law, and exactly what you can do about it. Let me give you the complete timeline, because understanding the sequence is everything. 2022, the three major credit bureaus, Equifax, Experian, and TransUnion, made 3 voluntary changes. Voluntary, not law, their choice. First, they agreed to stop reporting medical debt less than 1 year old. Give people time to resolve billing disputes before the debt hit your credit. Second, they agreed to remove paid medical collections from your credit report regardless of the amount. If you paid it, it should disappear. Third, they agreed to remove any unpaid medical collection under $500 from credit reports entirely, even if it is in collections, even if you have not paid it. If it is under $500, gone. These 3 changes took effect in spring of 2023. They are still in effect today in 2026. They are real, they are happening. And if you have medical debt that fits these categories, you can and should act on them right now. But, and this is the critical but, these are voluntary bureau policies, not federal law, not legally enforceable rights. Voluntary commitments that the bureaus can change at any time without notice. January 7, 2025, the CFPB went further. They finalized a rule that would have required the bureaus to remove virtually all medical debt from credit reports, not just under $500, not just paid, but all medical debt. $49 billion worth, affecting 15 million Americans. The rule was set to take effect March 17, 2025. It never did. Before it could take effect, it was challenged in federal court by the credit industry, the Consumer Data Industry Association, the Cornerstone Credit Union League, collection industry trade groups. Their argument, the CFPB exceeded its authority. The Fair Credit Reporting Act permits medical debt to be reported as long as it does not identify the specific provider or medical condition. The CFPB cannot simply override that. On July 11, 2025, the Eastern District of Texas agreed. The rule was vacated in its entirety, nationwide. And the court went further. It ruled that the CFPB cannot enact a similar rule in the future. The protection that 15 million Americans had been told was coming is not coming. Not at the federal level, not under the current administration, possibly not ever. Here is the practical reality as of July 2026. What is protected by the voluntary bureau changes? Still in effect. Medical debt under $500, not on your credit report, even unpaid, even in collections. Paid medical collections removed regardless of amount. If you paid it, it should not be there. Medical debt less than 1 year old, not reportable. Bureaus give you 12 months before it can appear. What is not protected? Unpaid medical debt over $500. This can fully appear on your credit report. This can affect your credit score. This can affect your mortgage application, your car loan, your apartment rental, your job background check. And here's the part the headlines never told you. Removing medical debt from your credit report does not erase the debt. Read that again. A credit bureau removing a medical collection from your report does not mean you no longer owe the money. The debt still exists. The hospital or collection agency can still call you, can still sue you, can still attempt to garnish your wages, can still obtain a judgment against you. The credit report removal was only about your credit score, not about your legal obligation to the debt. This distinction, the gap between credit report removal and debt elimination, is exactly where debt collectors are operating right now, and they're counting on your confusion. Let me show you exactly what is happening in the space between what most Americans believe and what is actually law. Loophole 1, the re-aging trick. When a medical debt is sent to collections, the clock on how long it can appear on your credit report starts from the date of the original delinquency, the date you first missed payment to the original provider. The debt can appear on your report for 7 years from that date. But some collection agencies, not all, but some, report the debt with a later date than the original delinquency. This is called re-aging. It makes the debt look newer than it is. It extends the period the debt appears on your credit report beyond the legal 7 years. Re-aging is illegal. It violates the Fair Credit Reporting Act, but it happens. And the only person who will catch it on your report is you. How to spot it? When you pull your credit report, check the date of first delinquency on every medical collection account. It should be the date you missed your first payment to the original provider, not the date the collection agency acquired the debt. Loophole 2, the zombie debt resurrection. The statute of limitations on medical debt varies by state. In most states, it's 3 to 6 years. Once that period expires, a debt collector cannot successfully sue you to collect the debt. The debt is time-barred. But, and this is critical, the debt still legally exists. A collector can still call you, can still send you letters, can still try to get you to make a payment. And here's the trap. If you make even a small partial payment on a time-barred debt, in many states, you restart the statute of limitations clock. A $5 payment on a 6-year-old medical bill you were never going to be sued over suddenly becomes a freshly actionable debt the collector can pursue in court. Some collectors know this. Some count on your guilt or your desire to clear the account, getting you to make just one small payment. Do not do it, not without understanding exactly what you're restarting. Loophole 3, the wrong amount collection. One of the most common and most profitable tactics. A collection agency acquires your medical debt. The original bill contained errors, overcharges, duplicate billings, incorrect coding. The collection agency doesn't know this and doesn't care. They attempt to collect the full billed amount, not the amount you actually owe after accounting for errors. You don't owe the inflated amount, but if you pay it, you'll never get it back. Before paying any medical collection account, request validation of the debt in writing. The collector must provide you with the name of the original creditor, the original amount of the debt, evidence that the amount is accurate, and documentation showing your agency is licensed to collect debt in your state. You have the legal right to this under the Fair Debt Collection Practices Act. Loophole 4, selling the debt after it disappears from your credit report. Your medical debt under $500 was voluntarily removed from your credit report by the Bureau. You believed it was gone. The hospital or clinic can still sell that debt to a collection agency. The collection agency can still call you, can still attempt to collect, can still, in some states, file a lawsuit to collect. The credit report removal was only about your credit file. The underlying debt still exists and is still legally collectible in most states. Here's one piece of genuinely good news, and it's important. While the federal CFPB rule was struck down, state legislatures moved aggressively. As of 2026, 15 states have passed their own medical debt credit reporting laws. Many of these went into effect January 1st, 2026. Colorado prohibits medical debt credit reporting entirely. If you're in Colorado, medical debt cannot appear on your credit report under state law. New York, New Jersey, Maryland, Illinois, Minnesota, Nevada, Delaware, Washington, Oregon, Connecticut, Rhode Island, Vermont, and New Mexico all have varying levels of medical debt credit reporting protection beyond federal law. If you live in any of these 15 states, your rights are significantly stronger than what federal law provides. Here is the critical caveat. The Texas court that vacated the CFPB rule also suggested that federal FCRA law may preempt some of these state laws. The legal landscape here is genuinely uncertain. State attorneys general in several of these 15 states are preparing to defend their laws in court. If you're in one of these 15 states, contact your state attorney general's office to confirm current status of your state's specific law. The landscape is moving fast.
Now, the action plan, specific, step-by-step, today. Step 1. Pull all 3 credit reports immediately. Go to annualcreditreport.com right now. As of 2026, you can pull your reports from all 3 bureaus once per week for free. This is permanent, not a COVID-era temporary change. Look specifically for these 4 things on every medical collection account. The date of first delinquency. Is it the original missed payment date or a later date? If later, that is potential re-aging and grounds for a dispute. The account balance. Does it match what you believe you owed? If it is higher than the bill you received, the amount may be wrong. Any medical collection under $500. If it is still on your report, it should not be there under the voluntary agreement. That is grounds for immediate removal. Any paid medical collection also should not be there under the voluntary agreement. Grounds for immediate removal. Step 2. Send the debt validation letter. If you have any medical collection account, whether on your credit report or not, and a collector has contacted you, send this letter. It is your legal right under the Fair Debt Collection Practices Act. Write down these exact words. I am writing to request validation of the debt you claim I owe. Under the Fair Debt Collection Practices Act, 15 U.S.C. 1692G, I request the following: the name and address of the original creditor, the original amount of the debt, documentation showing the amount claimed is accurate, and documentation showing your agency is licensed to collect debt in my state. I am not refusing to pay, but cannot do so until this debt is validated in writing. Please cease all collection activity, including credit bureau reporting, until this validation is provided. Send this letter by certified mail. Keep the tracking number. This letter legally obligates the collector to validate the debt before continuing collection activity. If they continue to call or report to the bureaus before validation, that is a federal FDCPA violation worth up to $1,000 per violation. Step 3. File the FCRA dispute for any medical debt that should not be on your report. Send a dispute letter to each of the 3 bureaus for any account that violates the voluntary agreements: under $500, paid accounts, accounts less than 1 year old, or re-aged accounts. Your dispute letter needs 3 things: the account you are disputing, the specific reason it should be removed, and copies of any supporting documentation. The bureau has 30 days to investigate. If they cannot verify the account, they must remove it. Send everything certified mail. Keep copies of every document. Step 4. If the collector violated the FDCPA, you can sue them. This is the one most people never use. The Fair Debt Collection Practices Act gives you the right to sue a debt collector who violates the law. The violations that most commonly occur around medical debt: calling before 8 a.m. or after 9 p.m., calling your workplace after you tell them to stop, threatening legal action they cannot actually take, continuing to contact you after receiving a written cease and desist, reporting inaccurate amounts, reporting re-aged debt dates. Each violation carries damages of up to $1,000 plus your attorney's fees, meaning an FDCPA attorney will often take your case on contingency, no upfront cost, because the collector pays the fees if you win. Go to NACA, the National Association of Consumer Advocates, at consumeradvocates.org. You can search for an FDCPA attorney in your state who takes these cases on contingency. Step 5. If you are in one of the 15 protected states, use your state law simultaneously. Contact your state attorney general's office. Ask about your state's specific medical debt protections. File a complaint against any collector or bureau that is violating your state law. State-level consumer protection cases often move faster than federal cases, and state attorneys general are actively pursuing these violations in 2026. There is one more tool in your arsenal that almost no one discusses and no debt collector wants you to know about: HIPAA. The Health Insurance Portability and Accountability Act protects your medical information, including the details of your medical debt, from being shared without your authorization. When a hospital or clinic sells your medical debt to a collection agency, the question of whether that sale violated HIPAA's restrictions on sharing protected medical information is a legally complicated and actively litigated issue. Some consumer attorneys argue successfully that medical debt collections that identify the nature of the debt that associate your name with a specific medical provider or treatment may violate HIPAA's information sharing restrictions. The CFPB rule that was vacated was actually grounded in a similar principle. The FCRA itself says medical debt can be reported as long as it does not identify the specific provider or the nature of the services. If a collection account on your credit report identifies the medical provider, hospital name, clinic name, that identification may exceed what the FCRA permits. This is not a magic wand. This is a dispute angle, but it is a legitimate one that generates results when applied correctly. When disputing a medical collection, include in your dispute letter a specific challenge to whether the account includes protected medical information and whether the identification of the original creditor constitutes identification of medical services in violation of FCRA 1681 BG1. That specific statutory citation, 1681 BG1, tells the Bureau's dispute team that you know exactly what provision applies. The language signals legal knowledge, and bureaus respond differently to dispute letters that cite specific statutes than they do to generic "I dispute this" letters. Here's where things stand as of July 2026. The federal CFPB rule is dead. The court said the CFPB cannot revive it. Any meaningful federal medical debt protection would require an act of Congress, which is not happening under the current political environment. The 15 state laws are in active legal jeopardy, following the Texas court's suggestion that FCRA preempts state laws. Several will face court challenges in the next 12 to 18 months. Voluntary bureau agreements, the under $500 removal, the paid debt removal, remain in place, but they are voluntary. They can be reversed. There is currently no federal law requiring them to continue. What this means for you: the window in which these voluntary protections exist may be finite. If you have medical debt that currently qualifies for removal under the voluntary agreements, act now. Do not wait for a political or legal environment that may never arrive. The people who act on this information today are protected. The people who wait for the government to protect them may be waiting for a very long time. What is actually protected in 2026? Medical debt under $500 voluntarily removed by the 3 bureaus, still in effect. Paid medical collections removed regardless of amount, still in effect. Medical debt less than 1 year old, not reportable, still in effect. What is not protected? Unpaid medical debt over $500, still fully reportable. The CFPB rule that would have protected everything else, dead as of July 2025. The 4 collector loopholes to watch for: re-aging, illegal, but it happens. Check your delinquency dates. Zombie debt, do not make partial payments on time-barred debt without legal advice. Wrong amount collection, validate every debt before paying. Post-removal collection activity, removal from your report does not eliminate the debt. Your 5 actions today: pull all 3 credit reports at annualcreditreport.com. Send debt validation letters on any active collection. File FCRA disputes on any account violating the voluntary agreements. Check your state's specific law at your state AG's office. If FDCPA violations occurred, contact consumeradvocates.org. Next week on The Objection, the lawsuit that debt collectors absolutely do not want filed against them, and how ordinary Americans with no lawyer and no legal knowledge are winning it in small claims court. If a debt collector has ever called you, next week is specifically for you. Subscribe to The Objection. They're counting on you not knowing your rights. That's exactly why we're here.